Welcome back to Nairobi Legal Insights. In our video today, our focus is going to be on administration, which is one of the subtopics under corporate insolvency and reorganization. We are going to achieve 5 key objectives, and by the end of the video, you should be able to appreciate a better part of administration in the Kenyan context. As demonstrated in this chart, in the course of this video, we are going to be able to appreciate what administration is all about, who an administrator is, when is this administrator appointed and by who. Then we are going to look into the objectives of administration and conclude the video by analyzing the key benefits of administration. Before we discuss what administration is all about, please take into consideration the previous videos we have had on corporate insolvency and reorganization so that you appreciate where we started from. So as you can see on your screen, administration is simply a rescue procedure. And using an example here, we may have company A facing serious financial problems. It can no longer pay its debts as they fall due. It is facing serious debt from creditors. And because of all these problems, an insolvency practitioner called an administrator can be appointed to step in so that he can revive this company to continue operating as a going concern. And when we say a company is to continue operating as a going concern, what we mean here is that a company can operate for a foreseeable future. So, administration is about reviving. How do we ensure that this situation that was so bad has changed eventually, that creditors are now going to be paid, the company is going to continue operating, so that all stakeholders continue benefiting from the operations of this company. The other key concept when it comes to administration is that once a company is undergoing administration, all legal processes are paused, meaning that if some creditors had gone to court and they had sued the company for default on payments, and then all those legal suits are going to be paused until this process of administration is complete. So within the period of administration, you cannot bring further legal suits against that particular company undergoing administration. And also if there were suits, then those suits are going to be paused. The other thing we need to appreciate about this process of administration is that we are trying to restructure. We are trying to ensure that this company finds alternative means of resolving its problems. And if the administration period lapses and of course the objectives have not been achieved, the next process will be liquidation. And remember, under liquidation, the company will exist no more. While when we take the approach of administration, a company can be revived. It can get a fresh beginning after, of course, reorganizing its internal financial problems and finding lasting solutions. When it comes to the appointment of an administrator, that can be done by the company itself, meaning that the directors and the management of the company can come to a decision that based on the financial difficulties faced by the company, the right decision is to appoint an administrator to step in and perform his duties of rescuing this company as a going concern. And we say that going concern is that a company is able to operate for a foreseeable future. We may also have a creditor or creditors applying to court for an administration order to be granted. And of course, we may have company A with several creditors, and they are worried that based on the financial position of the company, if it continues operating, it is likely to get worse and they will lose their money in the process. The creditors are going to lose their money. So they want an administrator to come in to manage the affairs of this company, to ensure that some secured creditors are paid, to ensure that the company is restructured in such a way that it can continue operating. And of course, this is all about reviving a company for the interest of creditors and of course other stakeholders within the company. Now, for this administration order to be granted, the court will need certain conditions to be met, One of them is that the court must be satisfied that this company is unable to pay its debts as they fall due, or is likely to become unable to pay its debts as they fall due. And then, of course, this is based on the factual evidence that is provided during this application. And the other thing is that the court must be satisfied that if this administrator is appointed, he or she is likely to achieve the purpose for which he or she has been appointed. So pay close attention to this. When you're seeking to apply for administration as a creditor, then of course it is not a guarantee that you're going to get this order, because administration comes with its own benefits. So you cannot just take advantage of the process. If you do not meet certain criteria, the court will automatically deny you an order of administration. The objectives of administration is that we are going to rescue a company as a going concern. Like we said, we want to revive this company to continue operating for a foreseeable future. And then, of course, you're trying to achieve a better result for creditors as a whole compared to liquidation. Like I stated, under administration, an administrator can try to put things right. He can pay off the preferential creditors and secured creditors. He can ensure there are some changes within the company so that it can continue operating. We are trying to revive the company. On the other side, if the administration procedure fails and the company is to undergo liquidation, then that company will exist no more. So liquidation, of course, will not yield better results for creditors. And then, of course, the other thing we need to appreciate is that the other objective of administration is that the administrator can be able to realize property and distribute it to the company's secured and preferential creditors. So if there were some secured creditors, when we talk about a secured creditor, this is a person who, of course, gave their money to the company and the company provided a security. So, of course, as you can see here, the administrator can realize this property and distribute it to this secured creditor. And then, of course, there is a hierarchy of creditors. We have preferential creditors, and we are going to, of course, be breaking down all these terms so that you understand them better. These are people who are paid first, based on the hierarchy. The key benefit of administration is what we call moratorium. And to break it down for you, what I mean here is that creditors cannot bring or continue legal proceedings against a company or its assets without the permission of the administrator or the court. So you see, the company has some sort of a breathing space where if there were legal proceedings that were pending, they're going to be paused. And if one wants to sue or bring a legal suit against the company or its assets, that of course will not happen without the administrator or the court's permission. Now, this key benefit, as you can see, is that we are trying to ensure that things are in order. Otherwise, can you imagine what would happen in a situation where a company that is in financial difficulties has several creditors, each one of them going to court to sue, seeking for repayment of their money? So the company will spend most of its time and the limited resources left trying to defend all those multiple legal suits. So as you can see here, by ensuring that we have some breathing space given to a company through what we call moratorium, that becomes a key benefit of administration as one of the procedures that a company could adopt if it is in a situation of financial difficulties. In our next video, our focus is going to be on the functions of an administrator and also looking into how long does administration take. Remember, administration cannot go on forever. There's a defined period for that. And once that period lapses without the administrator achieving the objectives of administration, then of course the next stage where the company can be moved to is to undergo the process of liquidation. Liquidation is the deathbed of the company. Here, we are not going to revive the company, but rather ensure that the company is no more. Up to now, you can tell that administration has better advantages based on, again, a certain context. You can be able to revive a company to continue operating as a going concern, but when all this fails, then we are going to liquidate the company. This is the deathbed where the company will no longer exist again. We are also going to be looking at what is the applicable law in Kenya as far as administration is concerned. And should you have any questions, these are our social media platforms. You can follow us on Twitter, drop us any questions you might have on LinkedIn. And then, of course, if you want to watch content on Nairobi Legal Insights based on a particular preference, click on playlist. You can be able to access all content categorized based on what you're looking for, whether it's employment law, intellectual property, insolvency law and reorganization. By clicking on playlist, you'll be getting videos already organized and put together. Thank you.